Welcome to the latest episode of Gateway to Data Protection and Privacy Special Series by EY India Insights podcast. I'm your host, Pallavi, and today we have an intriguing topic in focus: the impact of Data Privacy Act on the supply chain industry. To gain deeper insights into this matter, we are joined by an esteemed guest, Mini Gupta. Mini is a cybersecurity consulting partner at EY India. With over impressive two-decade-long career in risk management, her expertise spans across diverse sectors, including TMT, manufacturing, media, and financial services. Currently, Mini leads the cyber transformation in Africa, India, and the Middle East. She provides specialized consulting services in cybersecurity, data privacy, and technology risk based services to our top clients. Over the last 10 years, she has been very closely working on the agenda of data privacy in India and globally. Minnie, welcome to our podcast.
Thanks, Pallavi. Pleasure to be here.
To start off, we would like to ask, going by the newly released Act of DPDP, Digital Personal and Data Protection Act of 2023, as available on the website, who would be the data fiduciary in the logistics sector, especially in the cases where there are more than one transportation company involved for moving goods from start to the destination?
So, Pallavi, from a data fiduciary point of view, any entity who determines the means and purpose for processing personal data is the data fiduciary. So, in the case of a logistics sector, again, the entity who is engaging with the consumer to collect any personal information and then deciding who should this information be shared with is really the data fiduciary. So this could be the logistics service provider who will then in turn engage multiple transportation companies based on what the mode of movement is. But really the entity that determines the means and purpose of processing would be the data fiduciary. Now, if a transportation company is engaged by a logistics provider to move the goods, then the transportation company who is doing this on behalf of the logistics service provider becomes a data processor. So the fiduciary is still the entity that has collected the consumer's data or the personal data involved in this process and is sharing it then with multiple partners or transportation companies. Now, there might be certain cases where the entity itself is responsible for also processing the order and further moving it through their in-house transportation divisions. So it's really the same entity. The principle remains the same. Whoever collects and determines the purpose of personal data remains to be the data fiduciary, and everybody else in the chain who's enabling the movement on behalf of the first entity is really a data processor.
Thank you, Mini. With that, we see that the logistics sector has both organized players who have strong digital systems as well as smaller outfits with little in terms of data protection. How will the latter be monitored to ensure that they are following the proper protocols prescribed in the Act?
So the organized players, of course, should ideally take on the onus to train, educate, and sensitize the smaller outfits on the obligations of the Act, and more importantly, the need to protect personal data. Now, this personal data that may be shared with the smaller outfit ideally should be done in a limited capacity. So only minimum data that is required by the smaller outfit should be shared with them. And further, so one should also look and explore avenues of technology to be able to share such data. So rather than just passing on to the data to a smaller outfit, is there a way that the larger outfits can make the data available? So the minimum data that is required available to the smaller outfits in a secure digital way, could be through tablets, could be through a mobile app, such that they are exposed only to what is required and only for the period that they need that information for. So technology definitely will play a key role when it comes to sharing of data or making the data accessible in secure manners, because it may be too much or it may actually be difficult for smaller outfits to invest in security or technology themselves. The other aspect that companies definitely need to look at is to say, can there be contracts that can be signed? Now, again, when it comes to a smaller outfit, they may not have the capacity to sign onerous contracts or data protection agreements for processing the data that they are in custody of or have access to. So, hence, it may be required that as part of their, probably work orders or delivery contracts itself, there is sensitization and there are clauses included on their obligations to keep the data secure. But most importantly, the training and awareness and implication of what could really go wrong if data is not dealt with securely is something that the larger outfits will have to take charge of and sensitize the smaller players around. And technology measures will go a long way as well to kind of secure this entire value chain as information is shared across the board.
Thank you, Minnie. That's really assuring to know. Our listeners were also curious about the role of aggregators in logistics. We've also seen that there is a growing breed of aggregators in logistics who essentially provide the platform through which the individual transportation operators do business with customers. Who would become the data fiduciary in such cases?
So, in terms of aggregators in the logistics sector, now, if these are aggregators who are providing purely the platform to individual logistics companies or transportation operators, so it's only a tech layer. In this case, the tech platform aggregator is really a data processor, and it's really the logistics companies and the transportation operators who are using this platform for performing their operations to collect the data that is required to be processed, in turn probably share the data across the value chain. So so the entity that is the first point of collection and deciding the purpose and means of processing the data becomes a data fiduciary. The aggregator layer, which is purely providing the platform, will become a data processor. Now, if you look at the act, there is no direct obligation on a data processor under the latest data Digital Personal Data Protection Act in India. However, it is the onus of the data fiduciary to ensure that there are no non-compliances in the process. And hence, while the aggregators really become the data processor, the data fiduciary, which is the entity that is using the platform and having the data loaded on these platforms, have to ensure that the right means and measures and security controls are in place when it comes to these aggregator platforms. So, long point short, essentially the logistics service providers and the transportation companies that are collecting the data and deciding the means and purpose are the fiduciaries. The aggregators that are only providing technology platforms really become the processors and will be governed by the contractual clauses that they will sign with the data fiduciaries in turn.
Thank you, Minnie, for those valuable insights. Our next question focuses on the data principles consent and their control over the data. The Act allows the data principal to withdraw consent to the data fiduciary through the consent manager. How will this work in the logistics industry?
Now, consent, of course, is a mechanism that has existed in the global privacy and data protection regulations as well. Similarly, here again in the Indian Act, One can provide consent to process data. However, the Act very clearly says that while the data principal can withdraw the consent, uh, the data fiduciary shall ensure that within reasonable time they seize and cause its data processors to cease the processing of data, which means if I, as a consumer, withdraw consent from a logistics service provider, then the logistics service provider within reasonable time frame. Now, again, the exact time period is not defined. However, the logistics service provider has to ensure that not just they, but also all the processors in turn, whether it's a transportation company or other players in the value chain, also cease to process the personal data of this individual. Now, furthermore, it also says that in case on withdrawing this consent, if there is some consequence, so for example, as a consumer, I have provided information for the movement of goods, and hence the processing that is happening is for that purpose. But in turn, if I withdraw consent, then any movement that is impaired or hindered because of that would be the data principal's responsibility. So that consequence of the withdrawal has to be borne by the data principal. However, as a consumer, if I have provided a consent to my logistics service provider to send me some offers or maybe let me know some schemes, discounts that are coming up, and that is the consent if I withdraw later on, then as a logistics service provider, I have to ensure that in turn, all my systems and processes, or even third parties involved, who would actually be responsible or be a party to sending out those offers and discounts to this consumer, understand that that the consent has been withdrawn, and hence they should no longer process the data for that purpose. And any such processing after withdrawal of consent will actually go against the data fiduciary, even if it was done by a data processor. So yes, withdrawal of consent is a reality. And as a logistics industry, not just the main fiduciary who is the logistics service provider, but that party has to ensure everybody in the chain adheres to the changes in consent and stays clear of any non-compliance.
Thank you, Minnie. It's great to know that data principals will have the control over the data. Our next question raises concerns about the data misuse. There is a provision for fines in for a data fiduciary who fails to protect the data or misuses it. How does that help someone whose data is being misused?
So while these provisions penalize the data fiduciary, there is no mention in the Act on in any way compensating the individual who may have got impacted. Now, the entire intent of penalty is to act as a deterrent. It's not really about making money. It's really about saying how do we ensure that the protection of personal data is upheld, and to do that, these fines have been imposed. So while there is no provision for an individual to get compensated, however, we do have a data protection board that is getting formulated, and this body would be responsible to evaluate any such non-compliances or breaches. And they, while they will impose a penalty on the data fiduciary according to the gravity and the intent of the breach, it is up to this board to decide if on a case by case basis they may also want to in turn get the data principal compensated. However, for now, the penalty is really to act as a deterrent to ensure that strong governance mechanisms are put in place, and not really as a mechanism for individuals to get compensated. But in the event of any substantial losses, that can be taken up on a case by cases by the board.
Thank you, Minnie. And one final question revolves around the enforcement and the institutional capacity. What is the institutional capacity being built to ensure that the law is being monitored carefully in case of a data breach that harms the data principle? Will there be a separate agency to take it further, or will it go through a normal police channels?
So if you look at it, the latest, of course, act talks about the Data Protection Board that will act as a nodal body such that they will evaluate the cases, and in case of any such harms caused, then the data fiduciary will get penalized. In fact, there is a mechanism put up that also talks about having periodic reviews and independent data auditors being appointed in case the data fiduciary happens to be a significant data fiduciary. So, based on the volume of data handled, based on the sensitivity of data involved, based on other parameters such as risks associated with the processing of data, etc., a data fiduciary like a logistics service provider may be qualified to be a significant data fiduciary. And in such cases, there are additional provisions or additional obligations of having an independent data auditor and periodic audits so that there is continuous monitoring in terms of the compliances to the act. Beyond that, of course, we are expecting more rules to come out, which will specify further details of how these things will pan out. But the Data Protection Board definitely acts as a body that one could go to in case of any breaches that a data principal has. Now, there again, while that's a nodal body, there is also a provision of grievance management. So the Act very clearly says that the data principal can first reach out to the fiduciary themselves in case of a grievance. And if that is not satisfactorily addressed, then they can go to the board. And in fact, if that is also something that is not satisfactorily addressed, they have the provision to going further to an independent body. So while these things will further pan out, but there are mechanisms put in place, and the intent is very clear that the data principal will have ways and means of escalating further till their grievances are being met.
Thank you, Minnie, for sparing your time and breaking down those important inputs for us in on how the DPDP Act will influence the supply chain and the logistics sector.
Thank you. Thank you so much.
On that note, we come to end of this episode. If you would like us to explore other such topics on data security and privacy, please do leave us some suggestions that you would like us to deep dive into. Thanks for listening in. Until next time, this is Pallavi signing off.